I'm not going to put up with your nonsense any
What
longer.
nonsense
You
is
have,
it?
sir,
Listen,
you have.
nonsense. I never got a chance to see no video, nothing.
Is there anything else?
The judge is already losing patience, and that's never a good sign. When a judge feels like they're being misled or not given full information, things can spiral fast. So ask yourself what happened behind the scenes that pushed it to this point.
Nothing from the
Is
state.
there anything else? All right, that's all.
It was at this moment that he knew. He fucked.
Resorting to the use of illegal drugs. It's not helpful to anybody. It's not helpful to your mom. It's not helpful to your kids. It's not helpful to you. So I'm going to deny the request today, and I will see you at sentencing. Case number 26CR43293, the State of Ohio versus Casino Harris. You're Casino Harris?
Yes.
Mr. Harris is before the court with his counsel, Mr. Oswald. Ms. Tranter on behalf of the State of Ohio. Ms. Tranter?
Your Honor, my understanding is Mr. Harris is going to be changing his plea this morning. He's going to be entering a plea to count 1, aggravated possession of drugs as a felony of the 5th degree. State will ask for dismissal of count 2, and we do have an agreed recommended sentence to propose to the court of 6 months prison to be served consecutively to Mr. Harris's current prison term.
All right, Mr. Oswald, is that accurate?
Yes, Your Honor.
Okay, Mr. Harris, they're telling me you're going to change your plea to 1 count from the indictment. Before I get to your change of plea, I'm required to go over some things with you. Okay, sir?
R.
How old are you?
New case, new defendant, but same high-stakes situation. This is another plea deal on the table. And notice how quickly things move. In court, these moments can decide months or years of someone's life in just a few minutes.
26.
How far did you go in school?
I graduated.
So you can read and write okay?
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you other than this recommended sentence to me?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation you received from Mr. Oswald?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document called a change of plea. On the second page on the line marked defendant, there appears a signature. Did you sign this?
Yes.
Did you read this and go over it with your attorney?
Yes.
And you believe you understand what it says?
Yes.
This document says you're entering a plea of guilty to 1 count of aggravated possession of drugs as a felony of the 5th degree that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Do you understand the maximum penalty?
Yes.
You're also subject to a discretionary period of post-release control, which means upon your release from prison on this charge, the adult parole authority may choose to supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes.
Now, you're presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the prosecutor's witnesses. Do you understand that?
Yes.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes.
Do you believe you understand each of these rights we've discussed?
Yes.
You understand that when you enter a plea of guilty, you'll be waiving all these rights. We will not have a trial.
Yes.
Is that how you want to proceed today?
Yes.
All right, Ms. Tranter.
On or about June the 5th of 2025, Warren County, State of Ohio, the defendant Casino Harris did knowingly obtain, possess, or use a scheduled substance, being 5-fluoro-ADB, a Schedule 1 substance.
Mr. Oswald, anything on those facts?
No, Your Honor.
Mr. Harris, did you hear the statement that she read?
Yes.
Do you admit and acknowledge that what she said is true?
Yes.
And again, you understand all the rights you're giving up by
Yes.
entering a plea of guilty? You understand the rights?
Yes.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Ms. Tranter, anything before our sentencing?
No, sir.
Mr. Oswald.
Just ask you follow the recommended sentence.
Mr. Harris, is there anything you'd like to say before I sentence you, sir?
No.
All right, the court has considered the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. The court will order you to serve 6 months in prison.
And just like that, another guilty plea locked in. But here's the twist. Even with an agreed recommendation, the judge isn't actually bound by it. He can follow it or go harsher. So the real suspense? What happens next?
That to be served consecutive to your current sentence. The court finds that a consecutive sentence is necessary to punish this defendant. It is not disproportionate to the conduct of the defendant, and that this offense was committed while the defendant was already incarcerated in the Department of Corrections. You have 0 days jail time credit on this 6 months. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to this discretionary post-release control. Do you need me to go over that with you again?
No.
You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must
6 more months, stacked on top of time he's already serving. That word consecutive right there, that's the difference between doing time together or doing it back to back. And in this case, it just costs him even more of his freedom.
file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have any questions for me, sir?
No.
All right, best of luck to you.
Mr. Kirby, are we ready to adjourn?
Yes.